Well, good afternoon, good morning, good evening to all. We'll wait just a moment for others to join and then we'll begin. Well, again, welcome one and all. As others continue to join, let me begin our conversation. We only have a short time. It's a pleasure to see so many with us today. My name is Kathleen Claussen. I teach at the University of Miami School of Law, and it is my pleasure and privilege to moderate today's conversation on institutions and dispute settlement at the WTO. This topic does not need any introduction to this audience. We have gathered 4 experts today to speak to salient themes and the latest developments across this very hot topic. I'm privileged to introduce them now. Each of them will provide a short intervention, and we will be sure to save time for questions at the end of the hour. So we encourage you to submit those questions in the Q&A box at the bottom of your screen for the latter part of the hour. So first, we will hear from Gerardo Vidigal from the University of Amsterdam. Next, we will hear from Pınar Artıran from Istanbul Bilgi University. Then from Marcus Gustafsson, who is working at the European Commission, but speaking in a personal capacity. And then from Tommaso Soave from the Central European University. Each of these experts is well steeped in the topic of the day, as you will hear very shortly. Now, although this conversation has been on the calendar for many weeks, it happens to come on the heels of some recent statements by US officials about the future of WTO dispute settlement. Many of you will have seen this, including a statement by the Biden administration's nominee to be the deputy US trade representative in Geneva, Maria Pagan. So I can think of no better time to take stock of the latest, and indeed, here we are. So let us begin directly. We'll get right to it with Gerardo. So Gerardo, would you kick us off by telling us what it is that you're watching as we have found ourselves in this new sort of post-appellate body or temporarily without appellate body situation? Gerardo, please.
Thank you, Kathleen. Thanks everyone for being here and SIEL for organizing this event. So I'm going to focus on the taking stock part. So, I mean, what we've seen and everyone knows is over the past few years is the demise of the appellate body, right? So the appellate body stopped being functional in 11 December 2019. That's how much, you know, most of us actually know this date, which it says a lot, right? And so what has this meant? Well, first of all, it has accelerated what I think are some trends that we had already been seeing before, in part because of what the Trump administration was doing in anticipation of what is happening, and in part because the failure of the WTO to agree on a new round of liberalization, or at least regulation of trade relations, has meant that countries have been looking elsewhere for a while. And I like to think of this in terms of trends, right? So I think that there are 2 trends that we can think of, and one is decentralization, and the other is deinstitutionalization. By decentralization, I mean that the WTO and its rules, and in particular now this dispute settlement system, are no longer at the center of international trade relations. They have been let's say, already in jeopardy after 2008, when the Doha round when members failed to conclude the Doha round. But that was, let's say, as a rule-making institution, the WTO had already been losing ground to the likes of CETA, CPTPP, and now USMCA. But what also happened now is that we have increasingly dispute settlement taking place under these agreements. And over the past 2 or 3 years, we've had a number of, certainly 2 reports, but also a lot of either formal initiations of disputes or requests for consultations. There are some disputes going on right now. And then at the same time, these systems have become more active in a way that the WTO can no longer be, for 2 reasons. A, because it's unable to deliver a final report unless the parties agree to do so. and B, because many of these new rules that are being litigated under RTAs are not in the WTO agreements at all. So especially the rules on labor, the environmental protection, but also competition law. There's one, the US-Korea case on competition law. There's one on fisheries, which is a topic that should be coming to the WTO, but we don't know if it will. So you can see that the sum of a WTO that is no longer a reliable producer of a dispute settlement report, and a WTO that no longer has the most up-to-date rules on international trade governance means that WTO stops being the center. But the second trend that I would like to talk about is the institutionalization. And what I mean by this is that whether within or outside the WTO, trade relations are being, let's say, decreasingly addressed through institutions and institutional dispute settlement, which is a topic of our chat, but also more broadly through formal agreements and meetings. And increasingly we have what I call what is called tit-for-tat retaliation and direct negotiations. So when we think of the way the US-China trade negotiations are taking place, it's entirely through the so-called Phase 1 agreement, and that is entirely outside the scope of WTO law or any other rules that we normally thought of as being the international trade rules, right? So it's managed trade, as some call it. But then you also have the EU and the US agreeing on forms of managed trade with regard to cars, with regard to Boeing, Airbus. You already had there's some liberalization going on also outside of the WTO. So Mercosur has now somehow decided to liberalize trade agreements. Of course, you can have RCEP, which is far less institutionalized than other trade agreements. So what you have increasingly is states going back to direct retaliation as a means of settling disputes, and of course negotiations first, but then if not, rather than going to a dispute settlement system to settle the dispute, there is this sort of game of retaliation where in a way everyone loses. But this means that for lawyers, it means that there's, the kind of work you do certainly will be different, but also that it's a new game where new ideas have to be used, in the sense that the idea that you can always go to WTO is no longer there. But even within bilateral trade agreements, and I'll stop here, then the question of what is the value of a dispute settlement report within a bilateral relationship is to me more questionable than the value of the same report if it emanates from an institution that has the characteristics and the multilateralism of the WTO. Thank you.
Thanks, Gerardo. So if I may just follow up with a couple questions before we move on. Firstly, it's striking listening to you sort of describe, okay, we've got some degree of maybe what sounds like a bit of fragmentation risk, right? That is that first, if we move entirely away from dispute settlement, that could be one outcome. But if we just move our dispute settlement to these other different places, does that lead to greater risk for conflicting decisions, for example, as these different agreements proceed to the dispute settlement mechanisms? How does this interact with this long discussed issue of fragmentation? Thoughts on that?
So sure. So I think we're seeing fragmentation in many ways. Well, one of them is all of these rules and regulations that are different and sometimes entirely contrary to WTO law. And the second is that panels within these regional trade agreements can diverge from each other. I think the first case where it was clear was the labor disputes in Korea, EU, versus what happened in US, Guatemala. There were clear divergences there between what do you need to prove in order to show that a labor violation violates a trade agreement. Do you need to prove a relation to trade, and how far do you need to do that? Even within the WTO, now we've had this very interesting and in some ways striking report on US safeguards on photovoltaic products, where the panel essentially said, well, the appellate body has said some nice things about safeguards in the past, but here's our interpretation. So that shows that clearly the fact that there is not an appellate body, panels had disagreed with the appellate body in the past, But I think the extent to which this one does that is really unprecedented. So you can see let's say that even within the same institutional structure, we end up having fragmentation, and then the next panel, of course, can very well say, no, actually we agree with the appellate body, and then as an authority implementing these rules, you no longer know what kind of rule you're going to get once your dispute is challenged at the WTO.
Well, that leads me to ask you separately about the WTO reform. And here we are, a ministerial now just over a month away. You mentioned the Doha round earlier. How much of what you've just described really do you think is a direct reaction of a failure to negotiate that reform over the many years that folks have been talking about it, and maybe sort of looking ahead, your expectation in that regard?
So I can see two futures, right? One is that we are in what is it, in 1987 or something, where the GATT was no longer, let's say, the focal point for trade relations. You had all these voluntary export restraints agreements happening, and everyone knew that the GATT was no longer worked, or at least was not satisfactory to the contracting parties, and that created the impulse for the deal that became the Uruguay round, and that was finally led to a much stronger institutional system. So that's one outcome. The other outcome is that we are going to see this continue. This digitalization is here to stay, and that we are going to see a fragmentation really of not only of trade agreements, but of trade relations. And I think that's what's, let's say, dangerous, in the sense that it may actually be a danger for humanity, that we start seeing the two trade systems, especially with all of these decisions around Huawei, and now, I mean, there's a new one that I don't remember recall the name, that just happened, and the Biden administration just, I think it said China Telecom can no longer operate in the US. And then, of course, maybe next thing the U.S. wants it not to operate in Colombia or in the EU, and that's something that the U.S. can do because of its place in the global economy. And China could retaliate by saying, okay, now you have to choose whether you're going to be trading in the U.S.-centric system or in the China-centric system. And China is already the main trade partner for half the countries in the world, or maybe more. So we could see that fragmentation, and that, I think, would be very problematic.
Thanks so much. Let me get Pınar in here, because I can imagine now the hashtags going out, Gerardo, saying the danger for humanity with our current state of play here at the WTO. But I take the seriousness of your comment, Gerardo, indeed. So Pınar, you very recently spent some time working on disputes involving Turkey, as I recall. What's your take on the situation? Do you share Gerardo's view, or do you differ?
Thanks a lot, Kathleen. I mean, I couldn't agree more, of course, with Gerardo. There are many concerns where the WTO members might be interested in bringing their disputes to the WTO fora or the regional or bilateral dispute settlement system. Now, Gerardo talked about, the recent cases between the European Union and South Korea through their agreement, the free trade agreement on labor conditionality. We also have actually a case between the United States and Mexico through the USMCA, where we have seen the United States initiating on May 12th of 2021 a request related to the USMCA facility's specific rapid response to labor mechanism. So the United States there tries to approach Mexico on an environmental protection front, and they also try to, bring Mexico to embrace their commitments laid down bilateral environmental, customs verification agreement. But also we are seeing that the Biden administration currently puts really the United States trade policy in a worker-centered era. So we have also seen, and the European Union, South Korea free trade agreement goes along with the same line, but none of these issues are actually currently regulated in the World Trade Organization. So just like Gerardo has said, it's impossible to bring some of these disputes within the WTO fora. Therefore, it makes sense for the WTO members to seek guidance under their bilateral trade agreements, and to the extent they have a pre-established trade and sustainable development or labor chapters, they can benefit from these bilateral and regional trade agreements. At the same time, coming back to my experience with the Turkish Ministry of Trade, Turkey currently has an agreement, has a dispute with the European Union over pharmaceutical products in relation to the application of the national treatment provision and whether the Turkish system of reimbursing certain pharmaceutical products creates a discrimination on the basis of national treatment, etc. Of course, the case is still pending, so I wouldn't be able to talk too much about it, and it would not be my place to talk about it. But to me, what is interesting is what was the motivation for the EU to bring this dispute under the WTO, whereas we know that Turkey and the European Union have a customs union. Of course, for those of lawyers who are accustomed to Turkey-EU customs union, the dispute settlement chapter of this pretty old agreement from 1995 is not functioning well. So I think it would be a little bit harsh, perhaps, for the parties to try to, solve this problem under the Turkey-EU customs union, knowing that this agreement is not functioning on that front. And for the time being, they couldn't, modernize that agreement. So probably the only place where they could have solved this problem was the WTO dispute settlement. But on the other hand, we have another example where the European Union brought Ukraine, again, under the deep and comprehensive free trade agreement that is established between the European Union and Ukraine. And that case could have easily been brought before the World Trade Organization dispute settlement because there's an export ban and there are certain restrictions which could be super interesting for the other countries as well. So it's not really something that you would not be able to solve under the World Trade Organization dispute. So then one wonders, what is the rationale or motivation that pushes a WTO member to bring a dispute under the bilateral fora instead of the World Trade Organization dispute settlement system? So labor disputes perhaps are easier to entertain in terms of discussion because we have no labor regulation under the WTO. But anything that is being currently regulated under the WTO agreements, what is the point of bringing under the bilateral dispute settlement? So one of the possible answers we can give, of course, is this stalled and the non-functional dispute settlement system where, appeal into the void may create a big concern for the WTO member. So if they think that, to the extent a party will lose the WTO panel report, they will appeal into the void, then there's no point in handling and entertaining this dispute within the World Trade Organization. Therefore, I think the tendency that we're going to see with the WTO members, especially if they cannot solve their problem with the dispute settlement and fixing the dispute settlement problems within the World Trade Organization, like we're seeing with the European Union, they have a new tool to, create this new enforcement regulation whereby they'll try to bypass these problems that they may be facing with third countries. So one wonders whether there will be other members within the World Trade Organization who can come up with similar mechanisms that are similar to what the European Union does. But I will agree with Gerardo that probably to the extent the membership is not going to be fixed, the dispute settlement system, the multilateral one, they can increasingly use the bilateral system. But again, the issue which arises with it, I'm not sure whether they will always receive the jurisprudence or the case outcome that they are interested in getting, and they are always criticizing the WTO adjudicators for not coming up with. That's another question, Kathleen.
Well, maybe I can ask that, put that to you more directly, get your thoughts on that. Do you think this choice of recourse to bilateral dispute settlement in lieu of going to Geneva, does that have greater potential, shall we say, for achieving some of the policy outcomes that these states are hoping to achieve, or is it just another place where we might find ourselves subject to the same critique that we saw in the WTO process, some idea of activism on the part of individual arbitrators or adjudicators? What's your sense of that? Are we seeing better outcomes here? Could we?
Well, at least look at the EU-South Korea labor dispute. There you clearly see that the European Union is approaching South Korea for not, honoring some of the commitments that they should have under the ILO conventions and some conditionalities which come with the trade agreements, which you would not be able to do under the World Trade Organization. So to the extent your trading partner honors the result of the bilateral dispute settlement and starts, signing certain international agreements, changing internal policies, passing regulations, etc., I think it would show that it works. For the United States experience with Mexico, and again, one of the cases that comes to my mind is the famous Mexico telecoms case under the NAFTA. It could actually have been brought under the NAFTA dispute settlement, but at the time it was the United States' choice to bring the disputes to the World Trade Organization. So, it really depends on what kind of result you want to achieve. Do you want to get an awareness by, the totality of the membership and to, put your finger on a certain point where perhaps you're going to get certain, countries who are going to join their forces with you so that you can put pressure on a certain WTO member. But in terms of, judicial activism, etc., I think we may have less risk of judicial overreach or activism in the bilateral dispute settlement system, because first of all, there is no precedence, right? So this is an ad hoc dispute settlement system where the panelists are not really, doted to go back to what it was decided by the former panels or what the appellate body had said. So perhaps because there is less possibility of judicial overreach, this is an incentive for especially some of the WTO members that we know are super allergic to the idea of the precedent or binding jurisprudence. But at the same time, it's interesting for me to, when I looked at the panel report for EU-South Korea labor report, there are plenty of references to WTO principles, to WTO at large. So at the end of the day, one wonders, because this is international trade regulation, and because the bilateral trade agreements and regional trade agreements stem from Article 24 of the GATT, and the system is based on the rules under the WTO, to what extent can a panel under the bilateral trade dispute settlement diverge itself from the pretty established principles of this law? But I think it still remains to be seen. But at least, in terms of, again, for matters related to judicial overreach, etc., they might be on the safe side since there is no precedent probably under the bilateral dispute settlement system.
Great, thank you so much, Pınar. Let me come back to you in a little bit, but first get Marcus in here to tell us a little bit about. Well, Marcus, we've not really gotten into the U.S. critique directly. That is partly the U.S. critique that got us here. What's your sense, Marcus, of the state of that critique, and maybe what we should be focusing on now in that conversation? Marcus, please.
Yes, so thank you very much, Kathleen, and also thank you for SIEL for organizing this event. And yeah, I'll just repeat that my remarks are in my own capacity. They do not reflect the views of the European Commission. And indeed, in these remarks, what I want to do was to take a brief step back to the AB crisis itself, and indeed reflect a little bit on that, because I think that's helpful to see the way forward. And then if we go back to the blocking of the AB, which occurred originally in 2016, 2017, at that time, most agreed, I think, that was an attempt essentially to shift the system away from rules towards power, and to some extent back to the GATT. However, I think since then, to some extent, the US narrative, which was originally very narrow, focused on Rule 15, but then post ex facto also tried to paint the AB as a bit of a runaway, unaccountable institution to some extent. I think this narrative seemed to have gained increasing acceptance. So I want to start by briefly just pushing back on three aspects of that critique. So first, on accountability, you can only have increased accountability. And at the same time, you will have decreased judicial independence. So there is a trade-off between the two. And you can make sure that you appoint competent individuals, but there is really no serious legal system where you can have ongoing accountability mechanisms. So there, I think the system was working. And second, on the famous alleged judicial activism that Pınar was alluding to as well, I think if you consider three things. So first, the WTO agreements are incomplete contracts with negotiated ambiguity. Second, you do have a system of compulsory dispute settlement. And third, there is a rule that says that all claims must be addressed. Then I think a degree of gap filling is there by design and it's intended. And third, on the use of precedent, which has also been very controversial, this is, however, clearly key to creating what the current administration, U.S. administration, is referring a lot to as the rules-based international order. And I think if we look at the alternative, what the alternative would be that panels will try every matter de novo, and that does not help settle dispute. In fact, that generates disputes. And we see that, I think, in the FDAs, as both Pınar and Gerardo has been alluding to. And we've also seen that with regards to the searing disputes brought by the United States. Those are the same disputes coming over and over again. And I think that such a system, if that would be widespread across all issues, would be highly undesirable. And so I think here the point is that treating first like cases like, and second, relying on authority, which includes previous rulings, that's in fact inherent to judicial reasoning. And I think we do see this across different legal institutions. In fact, the now infamous cogent reason standard was borrowed originally from the European Court of Human Rights. And you also have the two-tiered Rwanda and former Yugoslavia war crimes tribunals. And they had a very strong system of precedent, which was articulated by those chambers. And finally, you have the European Court of Justice, which does not have any rule about binding precedent. And in fact, in its early judgments, it would just repeat the same formulations in different judgments. But very quickly, that got both complex and confusing. So it started to explicitly refer to past judgments. And in fact, today, it is extremely precedent heavy. So to go back to the WTO, the reason a permanent appellate body was set out was clearly to develop this consistent body of interpretive case law. And I think this is also reflected in part of the wording of the DSU. And in fact, the only field of law where we do not see much precedent is mainly commercial arbitration. But of course, that works because you do not have stable agreements. You have one-off disputes, and that would not work in the WTO context where we have the same agreements consistently. So I think to draw some conclusions out of that, I think judicial independence, modest gap filling, and reasoning from precedent, these were all foreseeable. And more importantly, they are highly desirable, especially in the trade system, which relies on predictability. So I think that does not mean that there cannot be compromise on some of those issues going forward. But especially with the current debate, I think there is a bit of a danger that they are not even being argued forcefully. That said, and as a final point, I would say there is one area of US critique which is justified, and that is that the system has become very complex. But here, actually, the MPAA is very interesting, I think. So there are 2 points. First, that the MPAA states that the arbitrator may suggest to the parties to drop Article 11 claims. I think there has been some agreement that the legal standards for these types of essentially factual claims should be higher, and this has been discussed a bit, I think. But second, and I think this has been less discussed, is that also MPAA arbitrators may suggest page limits. And in my mind, that is actually one of the few realistic ways to get to 90 days for appellate reports or 6 months for panels. And for my own work at the Court of Justice, this works very well to focus the dispute on the main arguments and the main claims. And I mean, it's interesting to note that actually back in 2016, the appellate body did suggest page limits. This was rejected by the membership. But I think going forward, that is definitely one reform that members should maybe reconsider. And I think there I'll end my opening remarks. Thank you.
Thanks, Marcus. you said a lot there. I will resist the urge to engage on the U.S. critique in great detail, but let me ask you one thing about the problem of complexity that you identified. And I wonder if, based on that problem, as you have suggested might be, would it not help then to simplify and have the panel stage be the only stage rather than have a two-tiered system? And do you have thoughts on that?
Yeah, so I think in the end, I mean, there are all these benefits with having the second tier. And so you improve quality just by having kind of second go at the same arguments. You make sure that they are thoroughly vetted, and you increase consistency. You prevent this fragmentation that Gerardo was speaking about. So I think it's better to have then second tier review, but narrow the scope. I mean, I work to some extent for a national authority, and I think for national authorities, it's important to know that an issue has been thoroughly debated, has been appealed if necessary, and also that it will stand for some time. As Gerardo was mentioning, there was, panels can have different interpretations. There's less consistency between them. And I think, just having panels that may settle the instant dispute, but you do not get any forward guidance, and actually national authorities become less, there's less incentive to actually implement rulings. And, over time, that's really corrosive, I think. And I think maybe it's underestimated currently that because there's this loss of guidance, actually national authorities are losing the habit of taking on board guidance and adherence to rules.
Great, thanks, Marcus. Let me turn to Tommaso, because now we've heard, okay, Tommaso, we've heard Gerardo's given us sort of the landscape. Pınar then gave us some of the policy implications and elaborated what the world in bilateral dispute settlement might look like. Marcus has told us about the critique, and what remains really is at least in part, the nitty gritty, the nuts and bolts. That is, what has all of this meant for everyday practices of trade litigation in Geneva? Can you speak to that, Tommaso?
Yeah, happily. Thank you, Kathleen. Yes, as you said, I think that an undercurrent, a theme in much of what has been said is a certain trepidation about the continued relevance of trade litigation in Geneva, which is potentially threatened by the recent developments, from decentralization of institutions, legal initiatives, weaponized narratives against the World Trade Court, using quotes as obligé in these cases. And I think that this trepidation is somewhat understandable. We all have vested interests in this. We are all members in a way or another at different levels of seniority of a social professional community devoted to the study and practice of WTO dispute settlement, or at least crossed WTO dispute settlement in our careers. So these threats to the relevance of the system also question our professional positioning, in a sense. And so this is a nutshell is the spin that I would like to give my speech for the next 4 minutes or so. So what is the impact of recent institutional developments for the everyday professional engagement of trade legal experts in Geneva and perhaps elsewhere? And so to answer this question, I will make two very simple points. The first is a mention of how everyday professional practices have shaped the old WTO dispute settlement system, if there is an old and a new, of course. And second, how those practices are adapting or failing perhaps to adapt to the evolving landscape. So starting with the first point, I think that much of the WTO dispute settlement ethos, as we used to know it, including perhaps this World Trade Court like appellate body that the United States dislikes so much, did not emerge from grand institutional design. It was not sort of hardwired in the book here, but emerged by way of recursive practices that took place mostly off the radar. And the makers of those practices are varied, of course. We have panelists and appellate body members, but also government litigators, private counsel, the Secretariat, and also scholars who participated indirectly in the making of the field. And so this community, as we know from, for example, from Joseph Weiler, has always been quite tight and relatively small. WTO hearing used to have the same counsel appearing over and over again alongside a variety of different clients. Secretariat lawyers had and still have very long tenure that makes them outlast, made them outlast appellate body members, and by design also panelists. Trade scholars often join the institution, either the bench, the secretariat, government departments. So revolving door and all that jazz. And so this cohesiveness, I think, has had a tremendous impact on trade litigation as we used to know it. It has impacted the way claims and arguments are framed and presented in the party submission. And I agree with Marcus that the question of page limit is relevant here, for example, as one of the many factors, has defined the internal steps through which cases are prepared and deliberated by adjudicators and the secretariat alike, the content and tone of the reports, and also the ethos and self-perception of the DS system. So this World Trade Court expression was originally a journalistic and scholarly expression that was adopted by a lot of academics that later joined the institution, especially from certain regions of the world. So this means that with the demise of the AB and these various developments, these practices are being dislocated, and there is a lot of repositioning going on. So of course, well, this will lead remains to be seen, but if we want to fully comprehend these future developments, we cannot focus only on formal law, say on the awards of the MPAA arbitrators or political chess play, but I believe also on a lot more, on the nitty-gritty, as you called it, Kathleen, on the types of focus that trade law firms will take, how they will reshape their relationships with old and new clients alike, how they will frame their claims and arguments in the future, how panelists and possibly MPAA arbitrators will design their internal division of labor and their working relationship with their secretariat assistants. That is a major bone of contention, or at least it was for the United States during the AB crisis. And I'm not even sure the MPAA has any assistance at all at this stage. And finally, and with this I conclude, how trade scholars and commentators will keep teaching and thinking, or evolving their teaching and thinking of trade law, how they will redesign their syllabi. I already know that in many parts of the world, including where I teach, a syllabus is no longer in WTO law, but in either international trade law or the practice of trade agreements, or you name it. So these are the nitty-gritty details, but I think that they offer a good key to understand what we are faced with.
Well, the latter point very much resonates with me, Tommaso. Apart from my own teaching having changed, I was at a conversation just a couple of days ago where those of us who write trade textbooks were wondering, okay, what does the new unit look like, right, in the next edition? And it seems a bit of a moving target, as you point out. Let me ask you and Marcus to elaborate just a little bit, and then I'm going to go back to Pınar and Gerardo briefly, but I want to remind our audience and the many experts we see there, new friends and old, that the question and answer box is available and open to you. I've seen a couple questions come in. We'll take those shortly, but do feel free to ask your questions to the panelists in that box, and we'll get to them in a moment. So Tommaso and Marcus, you both talked about redesign, reform, different aspects that, and you mentioned a couple different things. Would you say a little bit more about that? Either what other reforms? I mean, there are a lot of things floating out there. You know, so Marcus, what would you prioritize from some of the things that you said? And Tommaso, likewise, how should these practices be redesigned? Or more importantly, a question I think we ask less often is who should have a say in that design? So let me turn Marcus to you first, back to Tommaso, and then I'm going to Pınar on a different question shortly. Marcus?
Yeah, thank you. There's a couple, I'll try to be brief because obviously there's a lot to say and there's a lot of ideas out there. One of the things I think was interesting within the Walker principles was that you would have some kind of ongoing discussion between the members and the appellate body, for example. I think that is interesting because that does not take away from the judicial independence, but it's still a way to communicate and dialogue. And I think another thing that will also be important is to have this dialogue generally also between panels and an appellate body. I think going just slightly away from your question, though, on that point, I think that will also be very important now, given that, so we have the MPAA in place, for example, but going forward, I mean, what will happen, say that the MPAA gives a ruling and reverses a panel, and then another panel just makes the same ruling again in a different case. I think avoiding this conflict, and it was very interesting. For example, there was a recent interview with Van den Bossche where he talked a lot about how the AB was so isolated in the beginning to maintain judicial independence. I think maybe in today's climate, it would be even more important that panels, and also to some extent, you know, there are some flows of dialogue between MPAA and panels in the future, just as between membership and you know, those dispute settlement bodies, to make sure that there's kind of a mutual forbearance and mutual respect between these different bodies. So you try to, even though you're not formally obliged to, you try to kind of avoid conflict, to avoid essentially what would be these increased fragmentation. I think in concrete terms, also essentially what Tommaso has been speaking about, are a lot of these non-legal kind of not soft law tracks, but other types of institutional mechanisms to try to, you know, if we want to work together and have an effective system, there are some of those non-legal means to do so.
Thanks, Tommaso.
Yeah, thank you, Kathleen, for the excellent question. Let me not focus so much on the what should be changed, but on the who should have a say on changing practices, because I think that the ideas that Marcus has talked about are very interesting and very fruitful on a substantive level. I think that we are about to see, or we are already seeing probably, new forms of cooperation and competition between the political stakeholders, the delegations, diplomats, and this community of litigators. Probably they're trying sometimes to cooperate and sometimes to compete on who gets to say the last word. I think we need to resist analytically the temptation to say, well, institutional design is a given of states and practitioners only enter the field once the scene is set. I think that practitioners have a lot to say behind the scenes also about the directions that these new mechanisms will have. I think that the MPAA is a good example, with private practitioners cooperating with official stakeholders in the technical sort of definition of some of the details. But we are seeing that also in general in international economic law, so the UNCITRAL talks on ISDS reform there. Of course, we have a majority of diplomat state delegates in the negotiating room, but we also have a lot of scholars, top arbitrators, their collaborators trying to participate in these discussions. So I think that these forms of discussion will be sometimes cooperative and sometimes bitterly competitive, but I cannot, at this stage, I cannot say much more than this.
That's very helpful. Thanks, Tommaso. I wanted to go back to Pınar, because Pınar, you said a lot about the sort of policy choices facing states, and you among this group are best positioned to think about some of these recent things. Indeed, Gerardo also mentioned earlier, sort of compared this moment to 1987 in some ways, and yet while there are indeed some parallels, I agree with him on that. There are some significant differences, like our health emergency, and of course a variety of other economic emergencies related to the health emergency and hardship that members have been facing. And so I wonder if you could speak a little bit, Pınar, to something we haven't really talked about, is how, whether the WTO dispute settlement mechanism would be a place that could handle some of these national policy questions about space for those sorts of policies. What kind of a challenge would those policies pose to the WTO adjudicators, would you say?
Many thanks, Kathleen. Actually, this is something that I've been thinking quite a lot over the past year, that, you know, all of us around the world have been struggling to fight against the COVID-19 on a personal level because it's a health crisis. But actually, it has shown that the only crisis that we are facing, you know, both humans as well as governments, is not just a health crisis. yes, from one side, you would like to have access to the vaccines and you would like to, have access to the PPEs, etc. But at the same time, this, this cold war of trade that happens between countries like the United States, China, and to a certain extent, European Union, because they all, for instance, call China to be a strategic competitor. So the question which arises is that most of these countries are trying to become more resilient economically as well. So they are trying to focus on their critical dependence on certain, materials such as, raw materials, rare earths, or the shortage of, microchips and semiconductors, and all the, energy shortage, etc. It seems to me that the governments will start to, create and implement some policies that will require them to actually perhaps in a certain, extent to be in violation of the national treatment, obligation, because they all seem to embrace themselves for future crises where they will have to have a strong industry, I don't know, be it for semiconductors, be it for electronic commerce, be it for technology and digital era. So everybody is trying to embrace itself and brace for the impact. In such a scenario, if a country is too much focusing on the domestic industry to be strengthened, and to a certain extent where they will be using some norms on the localization or trying to, protect their industry, close the doors for a while. We all understand that, under emergencies, that's okay for a certain period of time. But it seems to me that this is becoming a sort of, systematic, challenge for the countries. Many countries around us, not just like the European Union, I guess, with von der Leyen Commission a couple of months ago, or perhaps it was last month, they declared that in order to be resilient, they need to introduce the EU Chips Act, etc., which are all understandable. I guess all of the countries are trying to pump up their resilience. But that leads me to question some of the basic principles of the World Trade Organization, such as the national treatment principle. To what extent the current Article 3 of the GATT and the way we interpret national treatment principle can be challenged by all of these, new practices of trying to build national champions, etc. So I think this is one of the problems that we may be facing in the dispute settlement. Another issue which comes to my mind again, you may say, well, if there are these kind of challenges, we can always invoke Article 20, Article 21, or Article 11 or Article 9 for that purposes. But for instance, for Article 20, let's assume you are fighting against forced labor, child labor, etc., and you would like to ensure that in the value chains that are entering to your country, in the products that you import, have been affected by the forced labor or child labor. To what extent are you going to be able to use Article 20, for instance? So yeah, you may say there are certain provisions such as the public morality, or to a certain extent for shortages of certain products, you may invoke Article 20J, or you can even say for prison labor, Article 20E. But in all of these situations, actually, you are making some value judgments about third countries' markets. In child labor situation, it's not your children who get affected, it's the children of the third country with which you're doing business, or they are in your global value chains. Then we need to talk about the extraterritoriality principle then, whether Article 20 will allow the imposition of the territoriality principle. So I think in the new term that we are facing, these are the critical questions that the dispute settlement organs may be facing when the countries are trying to become sustainably friendly, environmentally friendly, or labor friendly. All these questions will arise and we will need to find a question. And in terms of policy space, again, I think this is a very important aspect to it, because many of the countries who are currently redesigning their trade policy will have recourse to an argument where they will say, well, that's my policy space. After all, I'm sovereign, right? So I should have a right to organize the way in which I organize my market. But again, I think this is a very thin line. We have to be very careful. The policy-based argument, as we have seen in the WTO dispute settlement, is a very subtle line to draw. Due to the nature of the agreements in the WTO and the multilateral trading system, the freedom of action is constrained. So to the extent we're going to constrain the freedom of action and policy space of the WTO members, I think, again, we will have some problems which may be a little bit similar to the judicial overreach or judicial activism criticism coming from the members. So therefore, I think the policy space, if it's, invoked too much, can result in too many instances of uncoordinated national actions having an adverse impact on others. So yes, we recognize the sovereignty of country, but I think I see a risk there when we are playing, or when we will have to play with the policy space in the resilience, especially for industrial policies.
Thank you so much, Pınar. I'm glad we were able to get to that. Obviously, on everyone's mind, the pandemic and the implications of that. So I appreciate your sharing your thoughts. We've got some questions from the audience we're going to turn to now. First one I'm going to pose to Gerardo, and the question is, will these FTA dispute settlement mechanisms work procedurally? And Gerardo knows so well, we have a number of these experiments, right? What, for example, does the questioner asks, what is happening with the EU safeguards case against the SACU, which seems to be stuck in the composition phase? So Gerardo, thoughts on that?
So yes, I would say, so let me start from the specific case in question, because I think it's a very good illustration. It's true that traditionally there was a problem there, and I think especially the people from North America know that NAFTA became non-operational after the rosters of arbitrators were not submitted, etc. And so that was an issue. Now there are two solutions, of course, that you have a permanent issue of how do you compose a neutral arbitrator or panel. Now, there are two solutions for this, and one of the solutions, which the SADC EU EPA does not adopt, is to find some sort of authoritative institution, for example, the PCA, the President of the International Court of Justice, the Director General of the WTO, some RTAs, ask these people to appoint the third arbitrator or all three arbitrators in case the parties cannot agree. Now, the SADC doesn't do that. The EU SADC EPA doesn't do that. It does something else, which I think is worse. So what happens is that the joint committee has a trade and development committee. So the joint committee, that is both parties acting together, is assisted by a trade and development committee, and each of the parties chairs the trade and development committee alternately, so for a year. Now, because this, so what happens there is that we can assume that everyone is virtuous here, but we can also think that maybe it's not such a great idea, because your let's say temptation is to file claims when your person is chairing the Trade and Development Committee, and then you pick the chair, and this allows you very much to steer the arbitration procedure. I'm not accusing anyone of doing that, especially because, as it turns out, the EU has not done that, right? So what has happened is that the EU has requested this panel in 2019. They has requested consultations in 2019, requested the panel in 2020, and we still don't have a panel. What I understand happened, but maybe Marcus has better information than myself, maybe one of the watchers has, is that, and I'm getting this from a PDF presentation by the South African ministry, which I'm going to paste to the chat in a minute, where they say that the EU has delayed in 2020 establishing the arbitration panel until the COVID-19 pandemic passes. So I totally understand that this is a problem. But I can also see that this is becoming less of a problem because parties are becoming smarter, or at least more interested. I don't think any of these things are done lightly, but maybe they are. First, and second, even if this means that the parties are no longer entering into agreements where they forget how the dispute settlement might go wrong. And so I think in general we can expect, and I think another of the EU trade agreements, that is now the EU-Algeria, and it's called an association agreement, now has a panel composed. And of course, the EU-Ukraine system has worked, the EU-Korea system has worked as well, so I would be surprised by this. What I would like to point out, and I'll stop here, is that it's very interesting that we're basically what's happening in these RTAs, and that's very different from the WTO, is that the EU, the US, and Canada against the US are the only complainants. So what we're seeing is interesting in that the traditional way these things are working out is that the complainants are the developed countries. And in the WTO, of course, used to be, and it still is, a way for developing countries and smaller economies in general to challenge the policies of the larger ones.
Thanks, Gerardo. So we now have a long list, growing list of questions here, so we'll try and get to as many as we can. Let me turn to one, and I'll ask Pınar to speak to this. And then I'm going to come to Marcus next on a different question. So Pınar, the question is, what is the place of the EU-US Trade and Technology Council, this latest council we've heard about, for the panel going forward as another forum, for panels going forward as another forum to pursue convergence of rulemaking and standards and other such bodies? Do you think it contributes to institutionalization or fragmentation? Pınar?
Yeah, well, I mean, I think this is quite an interesting development that, of course, we all are closely watching. And this is something probably not just on a legal manner, but also politically and the transatlantic cooperation between the parties. Now, often we hear the argument that the regional trade agreements and bilateral deals offer some laboratory effects for multilateral trade negotiations. So to the extent we are falling short of some technology-related rules or electronic commerce or how to deal with the digitalization, etc., I think we need to just look at the final result of this cooperation between the European Union and United States. And I think we should not forget about the fact that even at the very advent of the creation of the World Trade Organization, many of the rules had been concluded with the initiation of these countries at the beginning. Of course, later on, there have been many discussions whether we like those rules, etc. But I think somebody has to start somewhere. And of course, the better situation would be, the ideal situation would be if China could be part of it. But since it is being perceived as the strategic rival, I think this will probably offer us a laboratory effect, and we can see actually the imposition of this towards the WTO as well. That would be my answer.
Thank you so much. Marcus, a question for you. This one is anticipating what might happen post-MPIA. That is, let's say an appellate mechanism comes online in the future. How will, the questioner ask, how will the WTO members who are not participants to the MPIA deal with MPIA decisions in terms of a precedential value? Can we imagine, how would we exclude MPIA decisions from somehow derailing the new appellate system that may be coming online? Your thoughts, Marcus?
If I understand the question correctly, I think, if the new system if there's a new appellate system that comes online, obviously then the MPIA would cede its place because it's an interim mechanism, and I don't think it's supposed to operate in parallel. What I was referring to before is more the case where if we say, okay, let's just have panels, I mean, maybe then there would also be agreement to not have the MPIA, but I think, a lot of members thinks that appellate review, for the reasons I mentioned, is really valuable. So I'm not sure they would concede. So if you end up in a system where you have the MPIA alongside panels over a longer term, you have this risk of conflict. And how do you deal with that? I think that's, impossible to say. I think the best would be if we have essentially what I was referring to as this, forbearance or mutual respect and, indirect dialogue where you try to avoid conflict as much as possible. But I mean, I don't think it's possible to completely avoid, but I think, judges are, if you have competent judges, I mean, they can sometimes be very good at sending subtle messages and kind of reading between the line. And hopefully you can keep this, a cohesive system for as long as necessary. But I mean, I think this underlines the urgency of getting proper appellate review back. And obviously, as you alluded to in the beginning, it's very positive to hear this from the US side last week, I think.
Thanks, Marcus. We're running short on time. There was one question that I'll open to the group, and to the extent someone wishes to respond, welcome your volunteering to do so, which is why don't we think about alternatives to dispute settlement? And that's something we haven't really talked about. The session title was Institutions and Dispute Settlement in the WTO. And so what about the institutions part? What do you think we should be thinking about in terms of the interaction between dispute settlement and the rest of the institution? Or as the questioner seems to suggest, what's the system that we should be thinking about where nobody needs to go to dispute settlement? Thoughts on that? Gerardo?
Well, I mean, it's in what situation? So I think we can. The question is, are we assuming harmony of interests here? In that case, sure. I mean, it's a possibility. But then I think it's not about reforming institutions. It's about reforming, I don't know, humanity, and then because normally people have differences, and you have to, the agreement. There is sometimes this assumption that you can somehow make the contract complete, right? But that's not how contracts work. They are inherently incomplete. And how far does Article 20 allow you to take measures and to protect what, and to what, and under what alternatives? Now we just had the news that India doesn't want labor to go into the WTO. But what does it mean for labor not to go to the WTO? I mean, it can mean that no one can take any trade measures with respect to labor abroad, or it can mean that anyone can take any trade measures with respect to labor abroad. So because it just you can say, well, it's not a trade issue, therefore you're not allowed to make any exceptions, or it's not a trade issue, therefore exceptions don't go to the WTO. You discuss it somewhere else. So the disputes are inherent to the system. The mechanisms, I know that, I mean, you can think of a very interesting example, I suppose, is the EU-UK rebalancing mechanism. And because that's what the EU wanted to do, what the EU wanted this rebalancing provision for level playing field, where it says, okay, here the EU could act unilaterally. But if you read the provision, at the end of the day, it's a sort of fast track arbitration. So you have a sort of negative arbitration, where if the arbitrators don't say no, then the EU can adopt its measures. But other than that, the alternative to that would be a unilateral action. And there are mechanisms that work through unilateral action. Those are, I think, the US-China, but also, if people are interested in, is the Inter-Korean Economic Agreement also works through unilateral action. Whenever a party is unhappy with the other party, they can just close, North Korea closes that part of North Korea where South Korea does business, or South Korea removes its companies from there. So that's the kind of measure we look at when we think of non-institutionalized dispute settlement. A third alternative, of course, is having permanent dialogue, and that's always possible. And I don't think in any agreement there isn't permanent dialogue. So the question is, what happens when you cannot reach agreement? And then we're not, maybe we need more creativity. But I wonder if there are any examples where where something besides unilateralism or some sort of multilateral assessment, or bilateral, of course, if it's a bilateral agreement, do work.
Thanks, Gerardo. Any last 30-second response to this major question from our other panelists? Pınar?
Well, Kathleen, I always wondered, actually, since I have started, working on WTO matters, this, famous Article 5 of the DSU on good offices, conciliation and mediation. Perhaps it could have been something to be used. I think the gentleman who is asking the question, could we have used, instead of going full litigation, is there any use to, to solve the problem in an amicable manner? I wish there could be more usage of Article 5. In the past, I believe there must have been some, recourse to Article 5, and the Secretariat could, provide good offices, etc. But perhaps, in certain, especially for certain disputes which are, politically very heavy and loaded, this is something perhaps needed because the stakes are very high. So therefore, I would just perhaps humbly recommend to make use of Article 5 if it's possible. That's my 2 cents.
Thanks, Tommaso. Last comment.
Yeah, so I don't know if you can avoid dispute settlement, but I think that we ought not to forget that at the WTO, any trade institution, there's always a double game going on at the same time. Even when legal teams litigate, political teams negotiate. And that has happened even during the appellate body crisis. Compare, I don't know, the US appellant submission in DS 437, it's available on the internet, with their statements on the powers of the appellate body. You will see that there's two forms of engagement, not only from the United States, of course, but from all major trade players. So never forget that these two things coexist.
Wonderful. Well, thank you so much to all of our panelists, Pınar, Tommaso, Marcus, Gerardo. Thank you so much for making time in your busy schedules to share your expertise with all of us today. Thanks to all of our wonderful listeners and to those who asked questions. We appreciate your engagement so much. And most of all, thanks to the Society of International Economic Law for hosting this conversation as part of its wonderful series, and to Maria Laura Marcedu for her organization of our group. With that, we wish you all a wonderful rest of your day, wherever you may be, and look forward to seeing you at the next conversation. Bye-bye.
Thank you, Kathleen, for chairing.
Thanks a lot. Bye.
Thank you. Bye-bye.
Bye.